Hello, my name is Katie Kohn, and I am a supervising attorney of the Domestic Violence Unit here at Legal Aid Service of Collier County. And today I am going to give a presentation about exploitation and abuse of vulnerable and elderly adults, how to identify and stop abuse. So what I'm gonna talk about today, first off, is why is this an important topic to address? Who is considered to be an elderly or vulnerable adult, specifically here in Florida? What are some signs of elder abuse and exploitation, and how can abuse and exploitation be identified? What is legally defined as exploitation of a vulnerable adult? And what are some remedies legally that you can do if you do know that someone is a victim of elder abuse or exploitation, or if you are a victim of elder abuse and exploitation? So first, just about why is this an important topic? Why are we talking about it? The statistics have shown that approximately 1 in 10 Americans over the age of 60 have been victims of abuse. So that is a pretty large chunk of the people who are 60 and over. In almost 90% of elder abuse cases, the abuse is committed in a domestic setting, so inside a home, and usually by somebody that the elderly person knows. In 60% of elder abuse or neglect cases, the perpetrator is a family member. And as we'll talk about in a little bit, this is one of the reasons why a lot of times elder abuse is hard to identify and why elder abuse does go underreported. This next bullet, it says incidents of elder abuse are reported in only 1 of 24 cases. So there's a significant amount of elder abuse that occurs that is never reported, that is never addressed. Much of that is because, as I just noted before, that most of the abuse is done by a family member or a caretaker of the elderly person. And there's fear by the victim that if the abuse is reported, they will have no one to take care of them, or perhaps the abuse will get worse. Also, there's a lot of times an issue of being able to have access to be able to report the abuse, or even knowing how to go about doing that. This is also a significant issue because elders who are victims of abuse have a 300% higher risk of death than an elder who is not a victim of abuse. And that is abuse, modest abuse. That doesn't necessarily mean significant physical abuse. It can be emotional abuse. It can be more minor physical abuse. Does significantly increase an elder person's risk of death. And there's also financial loss as a result of exploitation. And it's estimated that financial loss by elders who are victims of abuse or exploitation can be as high as $36.5 billion every year. So this is a significant issue. I think particularly here in Florida, where our elderly population is higher than in most places. So hopefully this presentation will be helpful to everyone, as most of us likely know somebody who is 60 years of age or older, or you may be yourself 60 years of age or older. So who are we talking about when we talk about an elderly person or a vulnerable adult? Here in Florida, the definitions are as follows. An elderly person is a person 60 years of age or older who suffers from the infirmities of aging, which is manifested by advanced age or brain damage or other physical, mental, or emotional dysfunction. And that dysfunction is to the extent that the ability of the person over 60 to provide for their own care or protection is impaired. It doesn't necessarily mean it's significantly impaired or totally gone, but there needs to be an impairment of that person's ability to take care of themselves. A vulnerable adult in Florida is defined as anyone over the age of 18 with an impaired ability to perform the normal activities of daily living or provide for his or her own care or protection due to mental, emotional, sensory, physical, or developmental disability or dysfunction, or brain damage, or the infirmities of aging. Generally speaking, anybody who is deemed to be an elderly person under Florida law is also going to be someone who is deemed to be a vulnerable adult, but you can be a vulnerable adult without being an elderly person. So if you are a person who's not over 60, but who does have a physical disability or some other disability that prevents you from performing normal activities of daily living or providing for your own care, you would be considered a vulnerable adult under Florida law. So what is abuse of a vulnerable or elderly adult? What are we talking about when we are talking about this abuse and exploitation? So the abuse of an elderly or vulnerable adult can take a lot of different forms. Of course, there's physical abuse, which is inflicting physical pain or injury on a vulnerable adult. It can include slapping, bruising, restraining physically, improperly using medication to keep a person restrained. Sexual abuse, which is any non-consensual sexual contact. Neglect, the failure by those responsible to provide food, shelter, healthcare, protection for the vulnerable adult, their failure to provide those things. Emotional abuse, which is inflicting mental pain, anguish, or distress on a vulnerable adult. And that can be through things like humiliation, belittling, intimidation, threats, and both threats of violence, threats of withholding care, things like that. Abandonment, so that's the desertion of a vulnerable adult by anyone who has assumed the responsibility for care or custody of that person. And exploitation, which is the really kind of refers to the financial abuse, the illegal taking, misuse, or concealment of funds, property, or assets of a vulnerable adult for either the person who's taking it or someone else's benefit without the consent of the vulnerable or elderly adults. So how can you identify if you yourself or someone that you know is a victim of abuse? And this can often be difficult to identify because with the elderly, the suffering is often in silence or is behind closed doors. Like I indicated initially, 90% of the abuse occurs in a private setting. So there aren't other eyes to see what's going on behind those closed doors. And that is why the abuse can often be difficult to identify. And it often requires alertness by people that may come in contact with the elderly person to really closely, look at the person and consider if there's been any changes. So some physical signs of elder abuse can be things such as dehydration, unusual weight loss, somebody who's missing daily living aids, such as a walker, a cane, their glasses, anything like that that they should usually have with them that sometimes they show up to a place and they don't have. They have unexplained injuries or bruises, cuts, or sores. If they have preventable injuries, such as bed sores, that may indicate that they're not being properly cared for physically. If their living conditions are unsanitary, or if they themselves have poor hygiene, or if they have any unattended medical needs. These can all be signs that physical abuse may be going on in the home or with a caretaker or something like that. Again, if you see any kind of sudden changes or even, some changes to the person's behavior or their personality, that can also be an indication that they're a victim of abuse. Some signs of emotional or behavioral abuse can include increased fear or anxiety, increased isolation from family and friends, unusual changes in behavior or sleep, and a withdrawal from normal activities. So these are some indications that someone is suffering from elder abuse if these sorts of they're exhibiting these sorts of behaviors. Financial signs of elder abuse can include fraudulent signatures on financial documents, unpaid bills, or unusual or sudden changes in spending patterns. A new will is drafted or other financial documents are drafted. If the person is all of a sudden deciding to maybe go visit an attorney's office with their caregiver to draft a whole bunch of new sets of documents, it may indicate that something, some sort of abuse is going on, or at least that some further investigation, discussion with the elderly person or vulnerable adult to find out if anything is going on, if there is real reason to be concerned that abuse is happening. So if you do find that abuse is going on, or you suspect that perhaps there is abuse going on, what can you do? The first is you can report the abuse to the Department of Children and Families, the Adult Protective Services Division. And in fact, in Florida, anybody who suspects that there is exploitation or abuse going on of an elderly person or a vulnerable adult is required to report that abuse to the Department of Children and Families. It is a requirement, and it's anybody. It's not only people that have specific relationships with the elderly person or the vulnerable adult. It's anybody that suspects abuse is required to report that abuse to the Department of Children and Families, and the telephone number is up there. The other option is if you are very concerned that the abuse is rising to level of a criminal issue, report that abuse or exploitation to the police, or if you suspect that it could be that severe, report it to the police. There are numerous criminal statutes in Florida law that criminalize the abuse and exploitation of elderly adults and vulnerable adults. It includes, intentional infliction of emotional harm or physical harm, failing to take action to protect an elderly person or provide proper supervision, not taking reasonable steps to protect an elderly person from abuse by somebody else, or encouraging somebody else to take an action that would be, tantamount to abuse. Of course, assault and battery, so physical abuse of an elderly person is a violation of the law. And theft or financial exploitation, again, are criminal. There are criminal statutes where someone can be prosecuted for doing that to an elderly person. I'm not going to get into discussing the criminal part of legal remedies, but again, if you suspect that somebody is a victim of abuse, report that to the police so that if there is criminal action to be taken, that can happen and the elderly person can be protected and removed from that situation. In addition, there are civil actions that can be filed for elder abuse based on negligence, recklessness, or intentional misconduct. Again, I'm not going to discuss those different civil actions. There are personal injury attorneys that can help you identify if what you are seeing with this vulnerable adult rises to the level of a civil action. And there's also, to protect the elderly person or vulnerable adults, you can file for an injunction for protection. And there are several different injunctions that we're going to talk about today. There's an injunction for protection against exploitation of a vulnerable adult, against domestic violence, repeat violence, or sexual violence. So we are going to kind of go through those options of filing for an injunction for protection for a vulnerable adult in order to get them protection from the abuse that they are experiencing. So first, what is an injunction for protection? An injunction for protection is a court order, a civil court order, that prevents the respondent, the person that the injunction is filed against, from doing certain things. And depending on the injunction that you file for, different things can be ordered. But generally speaking, an injunction will prevent the respondent from having any contact with the petitioner, or in this case, would be the vulnerable adult or elderly person. For exploitation, it's having access to the vulnerable adult's bank accounts, or being able to act on the vulnerable adult's behalf for financial matters, for medical things. It can also prevent any acts of violence or abuse to the petitioner. And an injunction can be entered until there's another court order dissolving or modifying the injunction, or for a set period of time. And that is generally, that will be a decision that the judge makes at a hearing on your injunction. So the first injunction I want to discuss is a relatively new injunction in Florida law. It is the injunction for protection against exploitation of a vulnerable adult. This is an injunction that I believe was first available to be filed in 2018, and it is specifically directed towards vulnerable adults. And again, many of the vulnerable adults in Florida are elderly individuals. But in order to file for an injunction for protection against exploitation, the petitioner needs to be a victim of one of these following kinds of exploitation. So it needs to be a victim of someone who has used or attempted to use the vulnerable adult's funds or property with the intent of depriving that person of those funds and property without the adult's consent. Or it can be that they've deprived or attempted to deprive the vulnerable adult who has diminished capacity of their funds or property, a breach of a fiduciary duty, or an intentional or negligent failure to use the vulnerable adult's income and assets to provide support and maintenance for that vulnerable adult. So in order to qualify to file for an injunction, the victim needs to be just one of those things, not all of them, only one of them. And the respondent, the person who's doing this exploitation, this abuse, has to be a person in a position of trust and confidence with the vulnerable adult. So for example, that can be a family member, a caregiver, a friend, a neighbor, anybody who has kind of put themselves in a position of trust and confidence with the vulnerable adult. That is not a specific legal relationship. There doesn't have to be any sort of specific paperwork identifying that person as a power of attorney or as a specific caregiver. It can be just somebody simply as much as a neighbor who repeatedly goes over to the vulnerable adult's house, and one thing leads to another, then all of a sudden it's a situation of exploitation where that neighbor has been able to exploit the vulnerable adult in a way by getting their money or depriving them of their property. Or it can be a person with a business relationship with the vulnerable adult, or a person with a fiduciary duty to the vulnerable adult. So a trustee, a guardian, or someone who does have power of attorney over the vulnerable adult. So if you are a victim of exploitation, one of those ways, by someone who essentially is supposed to be protecting the vulnerable adult, you can file for an injunction for protection against exploitation. So who can actually be the person to file? So the vulnerable adult, him or herself, can file on his or her own behalf. Many vulnerable adults are fully capable of still having the capacity to consent and file legal documents. And you can certainly file one on your own behalf if you are over the age of 60 and meet that definition of vulnerable adult. Also, a guardian of a vulnerable adult can file on behalf of the vulnerable adult if there's some reason that the adult can't file on their own behalf. A person or organization acting on behalf of the vulnerable adult, as long as that person or organization has the vulnerable adult's consent or has consent of a guardian if the vulnerable adult has a guardian. So that can be someone like an attorney can file on behalf of a vulnerable adult as long as they have the consent. And the last person who can file is a person who simultaneously files a petition for determination of incapacity and appointment of an emergency temporary guardian. So this is there because I think there's concern, or a lot of times a guardian may be accused of exploitation or abuse of the vulnerable adult. So if that is in fact the case, the only way you'd be able to file an injunction for the vulnerable adult is if you also file essentially to have that guardian removed temporarily, or if the vulnerable adult does not have a guardian and is not able to consent due to their capacity, you'd need to file an emergency temporary guardianship and then also file this injunction simultaneously with that petition. The other requirement is that whoever is the person who files for the injunction for the vulnerable adult must first report the alleged exploitation and abuse to Adult Protective Services, again, the Department of Children and Families, to the Florida Abuse Hotline. That is a requirement in the petition. You have to certify that you have reported it to the Florida Abuse Hotline. So what can be ordered in an injunction for protection against exploitation? So no contact with the vulnerable adult, the respondent, who is the caregiver, the family member, the neighbor, the guardian, whoever is being accused of exploitation, can be ordered to have no contact at all with the vulnerable adult. If the respondent and the vulnerable adult share a home, then it can be ordered that the vulnerable adult alone is granted exclusive use and possession, and the respondent will need to leave the home. It can order the freezing of assets or credit lines. And that's if a guardian or someone who has access to those credit lines is removing funds or assets that would prevent that. And those assets, credit lines, bank accounts, they can be only in the vulnerable adult's name. They can be in the vulnerable adult and the respondent's name, or even in just the respondent's name if there's allegations that funds have already been removed from the vulnerable adult and put into the respondent's account, and you want to prevent the respondent from subsequently transferring those funds out of that account. So those can all of those sorts of accounts can be frozen. The injunction can also allow, though, despite the frozen assets, the payment of certain expenses out of those frozen accounts to ensure that the vulnerable adult's necessary care is continued. So if there's things like rent needs to be paid, or payment for a caregiver, or for nursing care, things like that, that those bills can still be paid. But those need to be specified in your petition as to what funds need to be paid and out of which accounts. An injunction can also order a respondent to participate in treatment, such as anger management, batterers intervention, alcohol abuse, drug treatment, if those are issues that are identified in the petition. The injunction can also direct assets to be returned to the vulnerable adult after the case is over, or that they remain frozen if other subsequent civil actions need to be filed to determine, where those funds should go. And in this injunction, which is slightly different from other injunctions for protections in Florida, the court can order the respondent to pay costs both to the court and to the vulnerable adult. The court can also order any other relief necessary to protect the vulnerable adult from exploitation going forward. So in addition to the injunction for exploitation, there are other injunctions that a victim of elderly abuse can file to get protection from the person who is abusing them. So one of those is an injunction for protection against domestic violence. As we noted in the beginning, a majority of elder abuse cases are perpetrated by a family member can be a spouse, it can be a child of the elderly person. And in a domestic violence injunction, you have to show that you've been a victim of physical domestic violence, or you're in reasonable fear of becoming a victim of physical domestic violence. And that is by a family or a household member, such as a spouse or a former spouse, a person related by blood or marriage, people who are presently living together as if a family. So that's if you have a boyfriend or a girlfriend and you're living together, even though you're not married, even if you don't have children, but you're living together as a family, you could file a domestic violence injunction against that person if they are abusing you physically. And then also persons who are parents of a child in common, even if they are not married. In addition, if an elderly person is a victim of physical abuse by a caretaker who they are not related to, who they don't have children with, they are not living with, but that person has been physically abusive to them, they can file an injunction against repeat violence. And they need to show that they're a victim of 2 incidents of violence or of stalking. One of those incidents has to have happened within the last 6 months prior to filing the petition, which is directed against the petitioner or the petitioner's immediate family member. There's also another injunction for protection against sexual violence. If an elderly person is a victim of sexual abuse, they can file for sexual violence. They have to show that there's been at least 1 incident of a sexual battery or other forcible felony where a sexual act is committed or attempted. And the only other requirement is they have to report that sexual violence to law enforcement and cooperate with any law enforcement or subsequent state's attorney's office action against the respondent. And now just the process of applying for an injunction for protection. The first step is to complete a petition for injunction for protection and any of the other required forms. And also within that step is determining what kind of injunction for protection you want to or need to file for, what best identifies your situation, the kind of abuse you're suffering, and how can the injunction and the remedies that the injunction offers, how can that protect you going forward? And again, if you are an elderly person who the form of abuse you're suffering is really more of the financial kind, the exploitation injunction is going to likely be the one you'll want to file. If you are a victim of physical abuse by a family member, by a spouse, by a former spouse, the domestic violence injunction may be the one that you want to file for. And again, I would encourage anyone who finds themselves in an abusive situation or knows of someone who's in an abusive situation to consult with an attorney to find out what is going to be the best option going forward in terms of injunctions or any other action prior to filing, because that's going to increase your chances of being successful in court and getting the protection either you need or that vulnerable adult needs to stay safe. So once you've determined which injunction you want to file for, there's paperwork that is available online. It's also available in Collier County at the clerk's office. They can provide you with forms. And when you complete the forms, the forms ask you to specifically identify the incidents of abuse or exploitation. And it's important that you include all of the incidents of exploitation or abuse, starting from the most recent. When you have a hearing on an injunction for protection, you're going to be limited to talking about what is in the injunction, what you put in the petition for injunction for protection. So you want to make sure that you have included everything so that when you get to the hearing, you're not prevented from presenting certain evidence or testimony to the judge in regard to what has gone on and why you need protection. You want to be specific in your description of the abuse or exploitation, and stay focused on the specific incidents of exploitation and your fear and the fear of the continued exploitation. For the injunction for exploitation, you can attach affidavits to the petition that further support your injunction for protection. At a hearing, the individuals that sign those affidavits will need to be present to testify in person as to what they wrote in their affidavits. But for purposes of your initial filing, you can have affidavits to support your petition. Once you've completed the paperwork, you file your petition with the petition for injunction with the clerk of the court. In Collier County, the injunctions for exploitations are filed on the first floor of the courthouse at the clerk's office. For domestic violence, repeat violence, or sexual violence, those injunctions are filed on the third floor with the domestic violence clerk. And also for an injunction against exploitation, if there's a pending guardianship case for that elderly person or vulnerable adult, the petition must be filed in the guardianship case. If the elderly or vulnerable person wants to file a domestic violence injunction, those can be filed separately. Those do not have to be filed in the guardianship case. So after the paperwork is filed, a judge, generally that same day or at least within 24 hours, will review the petition for injunction to determine if the petitioner is in imminent danger of exploitation or violence by the respondent, depending on which type of injunction you file. And the judge can do one of three things. If they determine that the petitioner is in imminent danger of exploitation or violence, the judge will grant a temporary injunction for protection and set a hearing on the petition within 15 days. The judge can set only a hearing without granting a temporary injunction if the judge does not feel that the allegations rise to a level of imminent danger, or if the judge does not feel that there's adequate allegations in the petition to really sustain a final injunction at all, the judge can deny your petition. If your petition is denied, the judge must give the reasons for the denial, and then you can amend or supplement your petition to correct those things that may have led to your petition being denied. So if a hearing is set on your petition, the petition and the temporary injunction, if one was granted, will be served on the respondent by the sheriff's office. The next step is that you'll have a hearing, a hearing on your petition, and you will need to demonstrate through testimony and evidence that there is reasonable cause to believe that the petitioner was exploited or abused by the respondent or is in imminent danger of exploitation or abuse. So at that hearing is the opportunity to present any witnesses that may be a witness to the abuse or believe that you are at risk of abuse by the respondent, and for you to present any evidence in regard to the injunction for exploitation. That can include bank statements, other financial documents to show that you were exploited by the respondent. In an injunction for exploitation, the judge is going to consider all of the evidence and testimony, and when they're trying to determine if you are at risk of danger of exploitation, they will consider whether there's been other orders of protection issued against the respondent in either this, the current jurisdiction or anywhere else. The judge will consider a history of exploitation by the respondent, of the petitioner, of the vulnerable adult, or of any other vulnerable adult. Whether there's been a history of the vulnerable adult, the petitioner, being previously exploited or unduly influenced, and that can be by somebody else. The capacity of the vulnerable adult to make decisions related to his or her finances and property. And also the susceptibility of the vulnerable adult to undue influence. The last thing they consider is the criminal history of the respondent or previous probable cause findings by Adult Protective Services, if that's known. So those are the main things that the judge is going to consider. If there is evidence of any of those kind of factors, you're going to want to make sure to present those to the judge, as it will indicate to the judge the likelihood of continued exploitation and of past exploitation. After a hearing where both the petitioner and respondent present evidence as to the exploitation, the judge will decide whether to enter a final injunction for protection, or whether to dismiss the temporary injunction and dismiss the case. And just gonna go back here. Those steps in terms of the hearing is very similar in if you file a domestic violence, repeat violence, or sexual violence injunction. You'll need to demonstrate to the judge that there has been physical abuse in the past, or you're in imminent danger of abuse by presenting evidence through photographs, through testimony by other people who have witnessed abuse, through text messages or voicemail messages from the respondent indicating that the abuse has happened. And it's important that at that hearing on the injunction for protection, that regardless of which injunction you file for, you bring all of that evidence and those witnesses to that hearing, because that is your one opportunity to present what has happened to the judge. And that's when everyone needs to be there, and that evidence needs to be ready to present, so the judge has all the information when he or she is making the decision to grant or deny a final injunction. And the available remedies or the options for a final injunction are the same as we discussed earlier. So all of the things that were ordered in the temporary injunction or were able to be entered in the temporary injunction will remain, generally speaking, in a final injunction. So that's in regards to the contact, no contact by the respondent, exclusive use of a home, preventing the respondent from moving back into that home. And in regards to freezing of assets or payment of assets from frozen accounts, all those will be addressed at that final hearing and in the final injunction for protection. And again, once an injunction, a final injunction is entered, the judge can decide how long that will remain in place. It can be for a period of time, a year, 5 years, or it can be until further order of the court, until there's another court order that either modifies or dissolves the injunction. So, like I said previously, if you find yourself in a situation where you are a victim of exploitation or abuse, or you know of somebody who you believe is a victim of exploitation or abuse, I encourage you to report that to the Florida Abuse Hotline, report it to the police if you believe it rises to that level, and seek assistance from an attorney to determine what other actions you may be able to take to protect yourself or to protect a vulnerable adult that needs protection and may not be able to protect themselves or may not even be aware that the abuse is going on. So we're here at Legal Aid to provide assistance in those situations to determine if it's appropriate to file for an injunction for protection and assist you through that process. We also provide services for divorce, for paternity, and other family law matters. And we also have attorneys that assist with housing issues, tax, immigration, and consumer law. So any issues you may be facing, or you know of a vulnerable adult or elderly person who's facing those issues, I encourage you to call our office to see if there's any way that we can help. I also have listed here some other options if you're seeking assistance for an elderly person, or and specifically for legal help for those individuals. So there's the Department of Elder Affairs, Florida Senior Legal Helpline, Florida Law Help. It's a website that you can go to that has specific resources for older Floridians. The Department of Elder Affairs, Elder Helpline, can refer seniors to legal providers in your area. And then there's also the Florida Bar Referral Service or the Collier County Bar Lawyer Referral Service, where you can be referred to attorneys who may be able to help you if you are not able to qualify for services at legal aid. But again, I encourage anyone to call our office first to determine if you do in fact qualify for services, and we're happy to try to help in any way that we can. So that's all I have for today in terms of identifying and stopping abuse and exploitation of elderly adults. I hope that this presentation was helpful. If anyone has questions about this presentation, or if there's a specific situation you have a question about, please email me. My email is up there on the screen, and I'm happy to answer any questions or help in any way that I can. Thank you.